against Lezama.
Mr. Benjamin.
Good morning, my lords and my lady. My lords and my lady, as you know, I appear together with Mr. Pereira for the appellant. My learned friend, Ms. Teresa Haddad, together with Ms. Patsy Dindial, for the respondent. Mr. Stanley Marcus, who was on the list, cast list, is not appearing in the matter today, my lords and my lady.
Thank you.
My lords and my lady, the appellant is acutely aware of the burden that it has to discharge in order to persuade the board to, first of all, review concurrent findings of fact as to breach of duty and as to causation. We say, respectfully, that the board is entitled to depart from its established practice of reviewing such concurrent findings once it is satisfied that there has been a fundamental error amounting to a miscarriage of justice, as we say occurred in this case. The core moment when the courts below went wrong had to do with identifying the wrong question as to what Mrs. Karen Lezama suffered from. They compounded the misidentification of the erroneous question as to whether she suffered from post-partum hemorrhaging or whether, in fact, she suffered from disseminated intravascular coagulopathy. And I ask my lords and my lady to forgive me. I'm only going to say that once. I'm going to use DIC, if I may, because tripping up on myself for the entire morning would not be an attractive form of advocacy. So that when one comes to...
She did suffer from postpartum hemorrhage.
She did.
Come what may, didn't she?
She did.
Yep.
And the way that the first instance judge and the Court of Appeal identified the issue, and my lords will see this at paragraphs 157 and 158 of the judgment of Justice Rahim, and similarly at the judgment of Justice Barrow, and perhaps it might be helpful to take you to that now, is conveniently contained in the key documents bundle. I trust my lords and my lady have it. It's tab 7. Well, I know they're probably not tab, but tab 7 towards the back.
Yes, we don't have tabs. If you're able to give us electronic page numbers.
Yes.
We have the key documents, but for anything outside the key documents, we'll need electronic page numbers.
Absolutely, my lord. My lord, can I say now that the electronic page numbers and the physical page numbers are identical? So that's why they look slightly out of order. So I'm inviting you to electronic page numbering 100 of Justice Rahim's judgment. And he introduces what he says at paragraph 157 and 158 with the prefatory words at 156, that the case in large measure turns on these factual findings. At 157, he goes on to say the issue of fact is pivotal in considering whether the treatment of the deceased by the defendant, that's Dr. Achong, was reasonable up to standard. And he identifies this question: did the deceased exercise reasonable care, skill, and diligence in the treatment of the deceased in light of the diagnosis of the cause of death? Well, that's a generic question. It doesn't actually say anything. It doesn't take you any further on the facts of this case. To do that, we need to go to 158. And what he says there is as follows. The defendant, Dr. Achong, testified that he diagnosed the deceased as having an amniotic fluid embolus, henceforth AFE. He explained that this occurs during labor when amniotic fluid gets squeezed into the vessels of the uterus, which then goes into the lungs and creates a reaction in the patient. This reaction manifests in a combination of acute, it says respiratory, but it should be respiratory distress, acute cardiovascular collapse and a coagulation defect. Just pausing there, my lords and my lady, that's not postpartum hemorrhaging. It is not disputed, and this is important, in fact, it's vital. It's not disputed that these symptoms presented itself in the deceased case. So it was not an issue at all, according to the first instance judge.
Was there evidence of acute respiratory?
Oh, absolutely, my lord. Absolutely. So just to give you a flavor, and I'll take you to it in due course, both in his cross-examination of Mary Singh Bola, who is the obstetrician called on behalf of the respondent, as well as his cross-examination of Professor Dainsley, who is the pathologist, counsel for the appellant took the care to put approximately 12 to 14 symptoms of AFE. And to answer my lord's question, respiratory distress was one of them, that's A, and B, the notes from the nurses confirm that she suffered respiratory distress, and C, that fact was opined upon by Doctors Jabod, who was the expert called on behalf of the appellant, and Dr. Hemant Prasad, who was the expert called on behalf, well, he gave evidence on behalf of the first defendant, against whom the matter was discontinued. That's Dr. Withers. And each of them confirmed respiratory distress. So that, just reverting to the line that I was on, the important line comes afterwards. It is not disputed that these symptoms presented itself in the deceased case. What is in dispute is whether these symptoms meant that what was present was AFE or PPH caused by a condition other than AFE. And it's just as well to mention, before I come back to what I describe as the pivotal, the fundamental question, the evidence, the expert evidence before the court and accepted by the judge was that postpartum hemorrhaging, PPH, is an event, and that what is required by the clinician is to identify the cause of that event in order to determine the preferred or proposed course of action.
Well, you describe it as an event.
Yes.
In fact, on the death certificate,
Yes.
it was placed there.
Yes.
And reading it, it suggests it was identified as the secondary cause of death.
That is absolutely correct, lady, and I'm going to come to that. But I thank you for that, for getting me there slightly earlier than I intended to. It is absolutely correct that on the death certificate, in addition to what my lady just correctly pointed out, that the appellant identified postpartum hemorrhaging as a cause of death or a secondary cause of death. The primary cause of death that he identified was DIC. I'm resisting the temptation to try to say it out again. And that death certificate, so that's the documentary evidence, contemporaneous, is entirely consistent with the potted summary of the expert evidence I just gave in commenting on paragraph 158. So he goes on to say, so I've already identified the question that he set himself. What is in dispute? He says at that stage was whether these symptoms, and just to remind you, the symptoms are respiratory distress, acute cardiovascular collapse, and a coagulation defect, for which I asked my lords and my lady to treat as a synonym for DIC.
What was the evidence that there was any coagulation defect?
The evidence came from the appellant as to what he observed. That is to say that he found that the blood was pink and not clotting.
Yes.
And that
just means the bleeding wasn't stopping, doesn't it?
No, it doesn't, with respect. So, my lord, is helpful to...
It's the absence of platelets, is it?
My lord is ahead of me.
Yeah.
So, my lord is right in this respect, that in the presence of a coagulation defect, because of the loss of platelets, bleeding ensues. But what you observe, as in non-clotting blood, tells you that there is a difference between bleeding per se and a coagulation defect. And, my Lord, in any event...
You say that's observable?
Yes, observable, and that evidence, that is confirmed by each of the medical people, none of whom disputed or refuted what the debate that ensued between principally, I'm not excluding anybody else, but principally Dr. Bola Singh on the one hand and Dr. Jibod on the other, was not whether these symptoms were present, and I'll take you to Dr. Singh's evidence because I mentioned it twice already, not whether they were present. Her thesis was that, as my lady just pointed out to me, there was postpartum hemorrhaging, which she apparently inferred was much larger, more significant than what was recorded by the appellant and is recorded in the nurse's notes. So, by way of introduction to that evidence...
So, just before you go to the evidence,
yes.
Can I just take you back, please?
Yes, by all means.
To understand the steps in your submission, because
yes.
You're identifying for us, as I understand your submission,
yes.
the basis for a serious miscarriage of justice.
Yes, my Lord.
Before diving into the evidence, could you please, for us now at this stage, identify the steps in your argument?
Yes. My Lord, in order to do that, I need to just ask you to look at paragraph 168, which is where I was going.
Yes.
Which follows on from paragraph 158. And so the steps in the argument are as follows, my Lord. That the appellant's pleaded case was that Mrs. Lezama suffered from DIC due to AFE. And that at paragraph 168, the learned judge at trial declined to decide that issue. That error was partially corrected by the Court of Appeal, who identified it as a misdirection or material error, I think is the language that they used, or that the Court of Appeal used. And that's to be found at paragraph 14, and I'll take you to that in a moment. And this is just for your note.
Yes.
14, Roman 2. And that in identifying that error, the Court of Appeal itself erred in only partially correcting it, because instead of resolving the contest on the evidence, and as the court has gotten the flavor of, this is really a contest on the expert evidence, instead of resolving the contest on the expert evidence as to the reasonableness of the diagnosis, which each of the experts accepted was reasonable, i.e., each of the experts accepted in cross-examination that it was reasonable for the appellant to have diagnosed AFE as causing the DIC. Is my Lord with me?
Yes.
Instead of doing that and that alone, the Court of Appeal, with great respect to it, was distracted by making findings as to credibility or believability on the transcript, i.e., whether or not the appellant had in fact made that diagnosis. And so what we say is that the appellant's case was not fully and adequately resolved first of all by the erroneous as accepted by the Court of Appeal findings of the first instance judge, and then by the peripheral findings made by the Court of Appeal as to credibility and persuasiveness on the transcript, which we say were erroneous and not open to the Court of Appeal, respectfully.
And have I understood your submission correctly, that it is not only that the judge's, that the appellant's diagnosis was reasonable?
Yes.
But that was in fact correct?
Yes.
Is that right?
Yes.
Does this question go causation only, or do you say it has any effect on negligence?
If I were to weight my answer in response to my Lord, it's more heavily weighted to causation, but it does go to negligence as well.
How does it go to negligence, if you could explain that?
Yes. My respectful submission is that it's not helpful to the court to overly separate the two questions, because, and if I can give an illustration, one of the findings of negligence made by the first instance judge against the appellant was that he failed to seek blood and blood products early enough. So to answer my Lord's question, a correct and reasonable diagnosis of AFE required the administration of blood and blood products. As it happened, whole blood was administered in this case, and therefore it goes to that question in broad terms.
Sorry, I haven't followed that.
So
blood was needed anyway.
Yes.
And so it was equally negligent not to take steps to obtain blood, whatever the underlying cause, which in any event he didn't know for certain, and he had to cover all possibilities as best he could.
That's right, my Lord, and I accept that. So my answer is, my Lord's question to me was whether it is pertinent to the question of negligence and causation.
Yes.
The answer I gave is yes, it is pertinent to both.
Well, I haven't understood how it affects negligence. Sorry.
Well, my Lord, if the question...
Why is it any answer to his failure to make any reasonable steps to obtain blood that he thought it was likely that the underlying cause was AFE, if that's what he did think? Why does that bear on his, have any bearing on his negligence?
Well, my Lord, the treatment of AFE, because it's a coagulation problem, would entail the administration of either whole blood or a product which had clotting factors.
Yes.
Yeah?
Okay.
So it is relevant to the question of negligence.
Well, relevant in that it makes him negligent.
Well, my Lord, I was really answering my Lord's question as well. It's relevant to the question of negligence.
Well, by relevant, I meant of some assistance to him who presents some answer to negligence rather than demonstrating his negligence.
Yes, my Lord, and I'm going to come to that in a moment, if I may. But similarly, it is relevant to the question of causation because, well, my Lord, I think my Lord's question, I think my Lord, as it were, intuits.
Well, I see it could potentially be relevant to an argument that she would have died anyway.
Yes, my Lord.
But what I've still haven't understood, but you may want to have one more try, is to say that it could be any answer to the finding that he was negligent.
Well, my Lord, that requires us to go through each of the heads of negligence, which I will do.
I'm just focusing on the failure to obtain blood, and you've told me that if it was AFE, that made it essential to try and obtain blood to transfuse or clotting.
Yes, and he did.
Well,
Yes, but
Yes.
He did, but the question, did he do it in a timely manner?
Absolutely, my Lord.
And so the Court of Appeal says, well, even if it was AFE, the failure to get blood in a timely manner remained negligent.
Well, my Lord, I understood the Court of Appeal to say that what the appellant was required to do in the context of the evidence was to adduce evidence as to, or there needed to be evidence as to his efforts to obtain blood, because the evidence accepted both by the first instance judge and the Court of Appeal is that blood is in short supply in Trinidad, and
we'll come on to those points.
yes,
but
I was.
If questions such as short supply and the efforts made aren't on balance a defence, and the circumstance is that the court concluded that he was negligent in not asking for blood before he did, then does the fact that it was AFE rather than DIC combined with PPH make any difference to the question of negligence? That is the point that Lord Legate is putting to you. Purely in relation to the timely obtaining of blood.
My Lord, my answer to the court is yes, it is relevant, and it is pertinent, and I will come to the aspects and the evidence in relation both to the obtaining of blood, which is one ground of negligence, as well as the other grounds of negligence that were found against him, which have to do with seeking help and the proper hydration of the patient.
We'll let you develop your submissions. Thank you.
I'm obliged, my lords.
Yes,
my lord, I was
just before you move on.
Yes, my lord.
Sorry, but it's at it's a paragraph 93, isn't it, of the Court of Appeal?
Yes,
which is effectively saying, well, even if it was he was working on the basis of AFE, nevertheless there was still negligence. You're going to have to convince us that that was incorrect. Is that right?
Yeah.
At paragraph 90, oh, I'm sorry, my lord, I'm looking at
93 of the Court of Appeal, it's electronic.
Yes, right, sorry. I apologize, my lord, I was looking at Justice Rahim. So 93 of the Court of Appeal. Just give me 1 second.
It's the last sentence.
Yes, my lord. I will have to persuade the board, that that was an erroneous finding. I absolutely accept that. My Lord Kitchen, I wanted to make sure that I answered my lord's question. I'm not sure that I finished.
The question I was concerned to ensure I properly understood your answer to is whether or not the fundamental error amounting to miscarriage of justice extended to the question of causation.
Yes, it is mostly directed to causation, but it also has relevance to negligence in the way that I've explained.
Yes.
And of course, I mean, exactly as Lord Legate observed, because the evidence before the court was that AFE, though uncommon as a matter of absolute occurrence, is a common cause of maternal death. That was the evidence and was accepted, I think, both by the first instance judge and by the Court of Appeal. It is relevant, directly relevant to causation, and the appellant was entitled to have not only that question fully ventilated, but fully and properly analyzed, supported by an understanding or an appreciation of the expert evidence. And what I mean by that is by a proper understanding and appreciation of the interrelationship between these three medical phenomena: AFE, DIC, and PPH.
Well, to be fair to you, I don't think you do have concurrent findings on causation.
Well, Lord, I don't think I do.
The trial judge didn't decide the question.
Yes. And my Lord, that, in a sense, my Lord, that observation is another way of restating what I describe as my fundamental problem or my fundamental question. In other words, to the extent that the trial judge did not resolve the core or the key questions raised by this matter, then this appellant has suffered a miscarriage of justice. And can I try to summarize them in this way? What was the correct diagnosis for Mrs. Lezama? What was the cause of her demise in light of the correct diagnosis? And then lastly, but not unimportantly, of course, whether the appellant was negligent in any of the ways that were identified by the first instance judge and by the Court of Appeal. Now, in part, one of the reasons why the matter, so to speak, went awry has to do with the way that the case was pleaded. So with your permission, can I just invite you to have a quick look at the pleadings? I'm sure you've read them, but it's worth just having another look. It's common ground that what was complained of by the respondent, and just for your note, can I invite you to look at electronic bundle page 12, and I'm going to ask you to pay close attention to paragraph 10 of the statement of case, and then I will, and of course the particulars. But can I introduce my submissions in relation to the pleadings, and really by way of a closing comment in answer to my Lord Kitchen, that the case that the appellant had to meet was, and I'm quoting now from paragraph 10, page 12, electronic bundle, that the defendant, who treated and attended to the deceased at all material times, knew or ought reasonably to have known that the deceased was a gestational diabetic and or unknown bleeder, and was guilty of negligence, etc., etc. So that was the case that Dr. Achong was being called upon to answer. And in support of that case, and it's a very short statement of case, the substance of it in terms of liability comes to an end at paragraph 11 over the page on page 13. That was supported by 6 particulars. And as my lords and my lady know already, that case was rejected by the first instance judge. But it's important for my lords and my lady to identify, in a sense, that which is not there. There is on the pleaded case no alternative way of putting the basis for negligence against the appellant. Paragraphs 1 to 9 are prefatory averments, simply setting out what happened in the first 3 or 4 days of April, ending in paragraph 9 with the regretful and unfortunate demise of Mrs. Lezama. But the core of what the appellant was called upon to respond to is to be found there. And in support of it, and by way of the particulars, I mean, perhaps it's quicker if you just have a quick look at them yourselves. Failure to have regard to the record, failure to do blood investigations, failure to have sufficient blood on hand and so this is helpful and important in light of my Lord's legate's question to me, in the event of any need for such blood, and particularly so in the infant care, because she was a known bleeder. All of that was rejected. So none of the findings, whether as to negligence and or causation, revolve or turn on paragraphs 10, 1, 2, and 3. What the first instance judge and the Court of Appeal decided was that subparagraphs 4, 5, and 6, in spite of the absence of the words such as in the alternative, provided these are my words, not that of the courts, provided a standalone basis for attacking the professional conduct and behavior of the appellant. Now, it's clear that 4, 5, and 6 are not on a standalone basis. They're not separate, they're not apart, and they flow, perhaps inexorably is overstating it, but they flow from the substantive, the sharp of paragraph 10. My Lord, sorry, I thought you were about to ask me a question, my Lord Hodge. I apologize. I'm reading too much into my Lord's gestures. Now, just for completeness, well, you already know that the case was rejected. Of course, that case was denied, and I'm taking you to electronic bundles 17 and 18. And so the case that just as it were, these are, my Lord Kitchen, sort of further and better particulars of my answer. So the case that the appellant advanced, to the extent that he had to advance a case at all, the burden of proof being what it is, it begins at paragraph 15. He says that the defendant suffered AFE, and despite his treatment, which was in accordance to the practice accepted and regarded as proper, etc., she died as a result of acute cardiovascular collapse and DIC caused by AFE. So, my lords, when you read paragraph 15, I would ask you very much to have in mind that sentence that I read and reread from paragraph 158 as to the symptoms or the features that were present. His riposte to the case against him is to be found in paragraph 17. He denies that she was a known bleeder, but accepts that she was a gestational diabetic, and the expert evidence was that those two conditions are not remotely connected. I would ask my lords just to note paragraph 19, which says that no maternity clinic in Trinidad in 2003 at any rate has blood in the normal course, and that what the defendant did was to obtain such blood as could be obtained and treated the Mrs. Lezama. So firstly, my lords, we say that the threshold for this board feeling entitled, or we submit, is entitled to review the findings made below, whether concurrent or not, and I take what my Lord Legate has to say, on board. And of course, in our written case, we've identified what we describe as fresh findings as to negligence. We say that the pleaded case, the case that the appellant had to meet, was that he was treating someone who was a known bleeder, and in that case did not avail, and that, as it were, the alternative case that was not an alternative on the pleadings was where he was disadvantaged. It goes without saying that the purpose of pleadings, Macphermian times, Lord Wolfe, that the purpose of pleadings is to put each party on notice as to the case that they have to meet. Now, one accepts that with the advent of witness statements and so on, but it does set the parameters, as were the outer limits of what it is that any party legitimately can be expected to respond to. But more than that, legitimately can have found against them.
Can I just take up this pleading point? Because allowing for the point you make as to particulars of negligence 1 to 3, it could be said that particulars 4 and 5 are self-standing, failed to administer any or sufficient medication to stop the bleeding, failed to take urgent and immediate or any reasonable steps to stop the hemorrhage. And those are specifically pleaded to, are they not, in 19 and 20 of the defence. So irrespective of the cause of the bleeding, the defence is directed to those allegations.
My lady, I accept everything that you say, save and accept, and I accept as well that your observation is the view that the courts below took. But I don't accept that, A, that they are standalone, and even if they were standalone, my refutation of them in my defense, and of course I'm not counsel, but it doesn't matter, doesn't turn them into standalone allegations.
But is it suggested that there was any evidence that the defendant would have obtained but didn't if it had been more clearly spelt out, the case as it was later found? All the evidence would have been... Does this pleading point go anywhere of substance? Is he saying that there was some evidence that he would have adduced if he'd known at the outset that it was being suggested that he didn't get blood soon enough, for example?
My lord, I don't put it quite like that. I'm not going to. I don't think I can improve on the way that I've put it so far. My lady says to me that it could be said that they're standalone. We say in answer that clearly they are not, and that's an unfair outcome as far as the trial findings are concerned. My lord, in answer to my Lord Legate's question as to whether or not the appellant would have adduced different evidence, well, my lord, the short answer is that the course of the trial, as this court knows from its vast experience before you were all judges, that the course of a trial is not entirely predictable, but it is set on a set of rails for which pleadings are the appropriate limits. And so the pleadings tell you what to expect, and the pleadings tell you what are the bases upon which, if you are to be criticized for your professional conduct, that would take place.
Was any objection taken to the evidence given in the expert report by Dr. Singbola?
My lord, I'm not able to answer that question.
No, because I mean, her report was lodged in June 2011.
Yes.
And the trial was December 2011.
Yes.
So the defendant's team would know what Dr. Bola was alleging well in advance of the trial.
Yes.
Yes.
I accept that. And I'm sorry I'm not able to be of more assistance. I simply don't have the information. So, my lord, that's what I wanted to say about the pleadings. I've said what I wanted to say about diagnosis. And my lords and lady have, as it were, drawn me into some of the material that touches on negligence and or causation. Well, lords and my lady, what I propose to do is to proceed now in relation to what we say is the correct approach that should have been undertaken by the court as far as the expert evidence is concerned. So, my lords, lady, firstly, we say that the courts below were in error when they decided that causation had been established without any detailed analysis of the evidence in support of such a finding. And it's worth, as it were, to try to make good that submission, to take you to, first of all, the judgment of the first instance judge. So I'm going back to the key documents. I shall give you the electronic bundles if that's helpful to you. So I took you a moment ago to paragraphs 158, 157, 158, and we ended at 168. You will see what I said about gestational diabetes and known bleeder to be found in paragraphs 169 all the way to 180. And I just asked the court for its note where paragraph 180, the respondent's claim was rejected. So I want to skip over negligence. I'll come back to it. But I invite your attention to paragraphs 219. And I make the following submissions. So I say, first of all, as I said a moment ago, that what was required was a detailed analysis of the evidence, or put another way, the evidence or the lack thereof in support of the case for causation. And we say that the citation of the decision of the House of Lords of Belitho is correct. We have no difficulty with the citation. Our difficulty really flows from what comes thereafter. So that what one would have expected in the following paragraphs would have been a detailed analysis of the course of events, such as is set out in the chronology and or the agreed statement of facts and issues, identifying as best one could the cause or causes of Mrs. Lezama's demise. Well, that's not to be found at paragraph 220. It's a citation from a decision in the Court of Appeal, of which there's no difficulty. But we do rely upon the last sentence. So what is said there by the Court of Appeal is that causation turns on the medical evidence, and we say turns on the analysis of the medical evidence. And just picking up, without taking you to the case of Belitho, picking up what would have been expected, what was required, was either an analysis of the positive medical evidence and or an analysis and an identification of the expert medical evidence as to what would have been done by a competent practitioner to the extent that there is a complaint about omissions and the impact that that would have had on Mrs. Lezama. What we have instead is to be found on page 121, paragraphs 222, 3 to 4. And I shouldn't leave out paragraph 225. And then I will conduct a much shorter but a similar exercise when I come to look at the decision of the Court of Appeal. So having heard evidence from this range of obstetric experts as well as the pathologist, what the first instance judge decided was that at 222, when the evidence is considered in the round, there was no witness who could definitely say that the deceased would have survived had the defendant called for help, administered more medication, or gotten more blood at an earlier stage. Well, that's precisely what's required, with respect.
Well, it's qualified by the word definitively.
My Lord, I take on board the qualification.
It's a rather important qualification because what the learned judge is saying, these are not matters. We're dealing with counterfactuals. If there has been an omission, the counterfactual is what would have happened but for the omission. And what he's saying is this is a matter which we have to decide on balance of probabilities. So you have to read 222 with 224, and in particular what is said in the middle.
Yes, my Lord.
Paragraph 224.
And I'm going to come to that and try to persuade you to take a particular view or a different view, or view that agrees with what I've indicated.
Thank you.
So, my Lord, and can I just pick it up? My Lord's observation about counterfactuals, or the way that it's put in Bolitho, hypotheticals, no such evidence. And so that's the reason why there was no analysis. It's not that the judge in this particular case overlooked. I mean, there are a number of occasions when he did overlook quite important evidence. But no such evidence was adduced, is my point. So whether one characterizes such evidence as a counterfactual or whether it's characterized as a hypothetical, there was no such evidence forthcoming from Dr. Mary Singh Bola, but there was evidence forthcoming from Dr. Jibod in rebuttal, as it were, of the argument, well, here we can rely on the burden of proof on the balance of probabilities. In other words, what he said was, in short, AFE is a condition that can and does lead to maternal death, and that the appellant use all of the resources that he had available to him. Yes, more blood should have been administered, but no, he did not know whether any such blood was available. And we know on the evidence that it was not. And that's captured by paragraph 223. So can I go now to paragraph, at my Lord's invitation, to 224? So the learned judge poses a series of questions. Had the defendant obtained blood at an earlier intervention and administered it, would the patient have survived? Had he administered a larger quantity of syntocinon, would the deceased not have died? Can I just pause there, just to remind my lords and my lady that the syntocinon allegation is gone. It was set aside by the Court of Appeal. And you will see that in paragraph 14. I did promise to take you to paragraph 14, and I will do that in due course. But just for your note, so that had the defendant enlisted the help of an anesthetist at an earlier stage, would the defendant's negligence not have caused the deceased's death? No one can say for sure. Life is fragile in nature, and the answers to these questions will never be known. These are not matters that the claimant must convince this court of. So just pausing there. And he goes on to say the standard of proof required is that on the balance of probabilities. In other words, is it more likely than not that the omissions of the defendant in the treatment of PPH come back to our fundamental question. So, was the cause of death of the deceased by PPH? The body of testimony of all the practitioners appears to point in the same direction. They all point to administering more blood and blood products in the early stage an accepted method of treatment. The court interprets this to mean that the earlier the patient was given an adequate supply of blood, the more likely the patient was to survive an onset of PPH. So that treats the case as though, putting aside AFE, it treats the case as though there is no DIC. And this is important because no one ever put it to the appellant that there was no DIC. No one ever suggested that that which he said he saw and identified in respect to the clotting of blood and the loss of platelets and all the rest of it, no one suggested to him that that was false or mistaken evidence. So that this paragraph deals with, I hate to use fractions, but certainly less than half of the appellant's case, i.e., the uncontested part of his case. And that's important. The appellant had put before the court the question as to, for the court to determine, these are the two features of this lady's condition that I identified. Coagulation as well as blood loss, and I'm going to come to the details of them both in a moment. And I have ascribed a cause to them and treated with it accordingly. Dr. Bola, I'm just going back to the rest of the paragraph, that the sooner accepts that the sooner blood and blood products are replaced, the less the risk of organ damage and death, and she cited a UK report into maternal deaths. And one of the major factors in adverse outcomes with severe hemorrhage is a delay in initiating appropriate management. It follows that it's more likely than not that the omission to administer more blood and blood products in a timely fashion resulted in the death of the deceased, again, from PPH. And in answer to that case, the court says it doesn't accept the evidence of the defendant that the infusion of more blood would not have made a difference. And here, what you do not find in this paragraph, apart from the absence of the analysis of the counterfactors, you find no analysis or refutation or reference to the evidence of Dr. Jabod and Dr. Prasad. And he closes the paragraph by saying the answer to all three questions posed in paragraph 2118, it must be a reference to 221, I think, is therefore yes. And then he closes with his coda at paragraph 225 as to Herculean responsibility and so on, which reads to us as a qualification as to what is said in paragraph 224. Can I take you now to what the Court of Appeal had to say, very briefly? Now, bearing in mind that the Court of Appeal, as I've said on more than a couple of occasions, identified that there were material errors. This is at page 222. And those three errors, this is just for your note, failing to decide whether the appellant diagnosed AFE and whether such a diagnosis was reasonable. So that's a two-pronged question. And therefore, he failed to consider a major part of the case, anticipating, as it were, my submission about concurrent findings. Held that the judge was wrong to have held that Dr. Manning Allen's statement at the moment of delivery that she was a bleeder should have caused the appellant to act on it. And then thirdly, that the evidence did not support the conclusion that the appellant had administered insufficient dosages of syntocinon. So that's just a context for the conversation that we are having, which has to do with causation. Can I invite your attention, therefore, to 271? And there the Court of Appeal says that one, he didn't diagnose AFE, and I'll come back to that. But two, the more likely cause of Mrs. Lezama's death as deposed was massive PPH brought about by uterine atony leading to DIC and ultimately death. His original endorsement of the death certificate and application of uterine massage for forward support this view. He attempts to explain away the death registration. His attempt to explain them away was unpersuasive. And he says the fact that there was, open quotation marks, massive hemorrhages borne out by Mr. Lezama's account, a gush of blood and so on, and she was bleeding profusely, etc. My own suspicion is that the volume of blood lost by Mrs. Lezama is a lot more than he was willing to admit. I accept the evidence of Dr. Bowler set out at paragraphs 37 to 38 above. And just for completeness, can I just tell you what that is? If you go back to page 244, I trust my lady and my lords have it. That has to do with her challenge to the diagnosis of AFE. But what you will not see at paragraphs, so it's 37, 38, and 39. So to the extent that he leaves out 39, that's important because she conceded. He puts it as it was not unreasonable. In fact, I think what she says it was the reasonable diagnosis, but perhaps it matters not. So just reverting to sub-Roman numeral 2, for the reasons set out at paragraphs 83 to 97, I agree that with Dr. Singh Bowler that once PPH occurred, it was not managed to an acceptable standard. And so just pausing there, up to this point, there is nothing said by way of analysis as to the cause of death, other than what is said at the very top of the page, the more likely cause of death as deposed, so he's repeating the evidence, was massive PPH brought about by uterine atony leading to DIC and ultimately death. And can I just say that the evidence as to the extent of the blood loss as to PPH was that she had lost, in the initial stages, 500 milliliters, and then there was a further 300. So a total of 800. And I am going to take the court to a table of analysis provided by Mrs. Singh Bowler.
But that was your client's own estimate.
That's absolutely right.
Other evidence which the court was entitled to prefer, wasn't there, in the evidence of the claimant's husband and the evidence that she went into shock after about half an hour?
Well, she went...
And that her blood pressure dropped catastrophically.
Yes. So can I take each of those in turn? As far as there was no, as it were, volumetric alternative case. So that, yes, absolutely right, and I read it, I hope, and it's quoted there by the Court of Appeal as to what Mr. Lezama said he saw. And we say, with respect, that there was no refutation of the amount of blood that the appellant estimated. In other words, my lord, it was never put to him at any stage that... But
if you're the treating physician, you don't go on your decisions as to what to do, on what amount of blood you guess has flowed out by now. You go on what the signs are, don't you, of the blood pressure dropping and signs of shock, which call for urgent blood replacement.
My lord, the answer to my lord's question is no. You do go by volume loss because the evidence of Mrs. Singh Bowler was, and the evidence of the obstetricians was, that first of all, it is expected in the course of a delivery of a baby, even in these circumstances, that a pregnant woman would suffer some loss of blood. That's one. Number two, not all of the fluid that emerges would be blood. Some of it is amniotic fluid, obviously, because she's pregnant. Three, and it's helpful and again, I will take you to the table. Mrs. Singh Bowler's, Dr. Singh Bowler's evidence was that until it reaches 500 centimeters or milliliters, in agreement with that of the appellant, it wouldn't qualify to be PPH at all. Thirdly, as far as shock is concerned, the volume of blood loss and the drop in the blood pressure would require either one of two explanations, either a loss of blood far in excess of 500 or even 800 centimeters or milliliters, or, as in this case, it occurred almost immediately, and I will take my lords to the chronology, whereby the drop in blood pressure occurs in accordance with the agreed statement of facts and issues fairly early on. Can I just invite my lords to paragraph 15 of the agreed statement of facts and issues? So at 5:15, the following three things happen. That's 15, 16, and 17. Her blood pressure drops precipitously, way in excess of that which would be consistent, according to Dr. Singh Bola's evidence, with a loss of blood of either 500 or 800 milliliters. Her pulse was 111. The appellant's response was to add further syntocinon, and as well to give her Ringer's lactate, a volume expander, as well as Hemocell, which is a colloid. So it's an artificial blood substitute, and to introduce a catheter. So immediately that her condition presents, he responds as seen at 15, 16, and 17. Just for the context, you will see that this had occurred within the last 15 or 17 minutes. If you go back a page to paragraphs 10, 11, and 12. You probably already got there.
Yeah.
So at paragraph 10, her, Mrs. Lezama's stillborn male son, Ryan, I think he was named, was born. 12, he estimated that 500 loss. And here you will see, and the references are given, both to his with the statement and elsewhere, that the blood that was initially thick and red became pale pinky and watery as the bleeding continued. And so it was the pale pink, watery blood that signifies that it's not clotting.
Well, that made it all the more important for him to call for blood, didn't it, or clotting agents. He wasn't going to address that problem by administering Ringer's lactate.
No, but it was a proper response, according to Dr. Singh Bola, to administer the Hemocell, which is exactly what he did. And
well, it was nothing wrong with doing that. He was right to do that, but he should as well have been making urgent calls for blood, shouldn't he?
And I'm going to come to that momentarily.
Ringer's lactate is sodium lactate solution.
Yes.
Yes, and Hemocell is an intravenous colloid,
yes,
introduced in response to shock,
yes,
due to reduced volume of blood circulation. Neither of them is addressing, as such, a coagulation problem.
Correct. Yeah. Well, I accept that. I accept that.
So the reality is that on the table there is a woman who is bleeding. And
yes.
There is very heavy bleeding to begin with, then there's lessening of the bleeding.
Yes.
And what he is trying to do, as I understand it, at that point, is stem the bleeding.
Yes. Right. Yes.
And he does so without assistance.
Yes. I don't want to be unfair to Dr. Manning Allen. So Dr. Manning Allen is a very senior and distinguished and very highly respected pediatrician, but a personal friend of Mrs. Lezama, and she was in the room at the time that the baby was born. In fact, that was her primary purpose for being there, and she did provide him with such assistance as she could For instance, it was Dr. Manning Allen who summoned Dr. Harold Chang, who was the anesthetist. It was Dr. Manning Allen who went with Mr. Lezama to another private institution called Sinclair to obtain whole blood, because that's an institution with which the appellant was connected. You see, it's not in the evidence, but so I won't say what the connection was. And we say, or we rely upon Dr. Manning Allen's evidence, which was a revelation to us, that when she went to the blood bank to seek more syntocinon, she was asked by counsel whether she was able to obtain blood from the blood bank, and she said that she was not able to.
Well,
Is that what she said?
I'd much prefer to take you to the evidence rather than...
Please do. I mean,
Yeah.
I have read that piece of evidence.
Yes.
you'll find it at bundle 2, beginning at page 477 and going on to 478. And in particular at 478, you can pick it up at, say, 38 on. I beg your pardon, 30 on.
Did my Lord, is it helpful for me to take you to that evidence now?
Well, you've made the point.
Yes.
And you're being asked whether the evidence goes
Yes.
as far as you are
Yes,
stating.
and I So can I take my lady's suggestion and pick it up from page 478? But just can I go back to line 14, my lady, if you don't mind?
Yep.
Right. So, in fact, no. Can I invite you respectfully to go back one more page to 477? Line 40. And you're leaving to go to the Port of Spain General Hospital, according to you, to get syntocinon, correct? Yes. You made no inquiries at that stage of the blood bank as to whether you could get any units of blood for Mrs. Lezama, did you? I did. You did? Yes, I did.
That was a surprise to the cross-examiner.
Yes. Well, my Lord, I want to be careful about looking into his mind, but that's how it read to me.
That's how it read to me.
If it reads well, my Lord, then I feel comforted. And where exactly in this witness statement is it? I did not record that. I did not record that. And what were you told by the blood bank? So just pausing there. Counsel is asking a question to which he doesn't know the answer. I had, sitting in the waiting room of Stanley's maternity clinic, the senior technician from the hematology lab at Port of Spain, who had access to the blood bank. I'm asking you, what did the blood bank tell you? Because you've now told us for the first time, you made inquiries in the afternoon as to the availability of blood units from the blood bank. You accept that? Yes, I do accept that. So that's a reiteration. You told us for the first time now. Yes, I accept that. Sorry, I do accept that. You didn't put that in your witness statement. No, I didn't. And my question to you is this. Before that, at what time did you make the inquiry? I didn't make it prior to going for the syntocinon. I'm asking you what time. I know that it was before dusk. It was daylight. I don't know exactly what time. And what were you told? The person of whom I made the inquiries was a senior, I'm not sure whether, Dr. Manning, I'm interested in what you were told. I was told that we would get whatever we needed, but you did not, in fact, get any units of blood from the blood. Dr. Manning, allow me to finish my question, please. You did not, in fact, get any units of blood from the blood bank on the 6th of April, 2003, did you? And then Dr. Manning says he needs protection. He goes over the page. And then it picks up again, line 20. You received no units of blood from the blood bank for Mrs. Lezama on the 6th of April, did you? I did not.
So that's it. She's told that she could get whatever she needed, but for whatever reason, and the reason wasn't put before the court, she didn't obtain it.
Yes.
Right.
Well, that's the point. We don't in fact know from this evidence that the blood wasn't available. We know that she was told it was, and we know that she didn't get it. As to why?
Well, my Lord, can I take, with great respect, the strongest challenge to that in this way, and of course respectfully. the evidence among all the experts is that blood is not readily or easily available in Trinidad and Tobago. That may surprise you, but that's...
Well, I'm aware that there is that evidence.
Yes. So that's one.
If I may say so, I think that cuts both ways, doesn't it? Because if you have the clinician carrying out a procedure and then is suddenly faced with very heavy hemorrhaging,
Yes.
one might have said one of the first thoughts are, I've got to stem the blood and I need more blood. If
Yeah.
that clinician knows there are difficulties of getting blood,
Yeah.
surely it's particularly incumbent on him or her to make every effort to get blood as swiftly as possible.
Yes. But that's...
And he doesn't.
Well, that's one half of the equation. And I appreciate that you are... Let me go back to what my Lord Hodge said to me a moment ago as to the way that this evidence is read, or is respectfully, it is to be read. We say that the evidence means exactly what it says, that a senior physician, on behalf of another senior physician...
Not on behalf of. There's no evidence that your client knew anything about this. He didn't ask her to ask for more blood. He took no steps at all in that direction.
Well,
The highest this goes is that, unknown to him, this witness might have made an unsuccessful attempt to ask for some.
Well, it might, I think, has to be emphasised, because she asked a question, she was told there was no blood, she was never asked, did you ask for blood at any stage from the state blood bank? She was merely asked, you didn't receive any units from the blood bank, did you? No, I didn't.
no, my lord, I thought that I read, unless again, my lords, forgive me if I am misreading or misremembering what I thought I just read.
No, we can all read what's there. Yeah.
My lord, absolutely, and forgive me if I'm being slow. I obviously am.
Not at all.
You made no inquiries at that stage of the blood bank as to whether you could get any units from Mrs. Lezama, did you? And the answer was, yes, I did. That's at the bottom of page 477.
Yes, but she was told that the answer to the inquiry was that she would get whatever she wanted. That was
well, my lord, I'm going to come to that in a second. I don't want to, I've asked my lord not to,
Okay.
I don't want to run from, I have to deal with this evidence.
Surely.
And I have to, of course, I have to treat it.
Do it your way.
No, my lord, I'm hoping that we can do it our way. In other words, I'm gonna subject myself to my lord's discipline of, I hope, objectivity. I am not trying to make a subjective submission here. I'm simply saying that this evidence is that the question was asked whether she made inquiries, and she said, I did.
Yes, that's 478, line 18.
Right. And going over the page, further and in support of the inquiry, and I'll come to my Lord's legate's suggestion a moment ago that it could not have been behalf of the appellant. I'll deal with that in a second. I mean, I have a submission on it. But over the page, he says, well, listen, I had sitting in the waiting room at Stanley's a senior technician from the hematology lab at Port of Spain Hospital who had access to the blood bank. And counsel presses her, well, tell us what you were told. And she was told that she could get whatever she wanted, but in fact, she didn't get any. So those two answers are line 36, and over the page, the question is at line 40 to 43, and the answer is line 23 over the page. So, my lord, I take from that the following. that Dr. Petronella Manning Allen attended at the blood bank and made inquiries for blood for Mrs. Lezama. That's one. Two, she did not succeed in obtaining any. Three, she made those inquiries for the benefit of Mrs. Lezama. And fourthly, we say that she made those inquiries for the benefit of Mrs. Lezama for and on behalf of the appellant.
And where is the evidence of that?
And so, my lord, I accept that there is no evidence coming from the appellant.
Well, you would have thought that if he told her to, it would have been the first thing he would have put in his witness statement.
My lord, I cannot say to you that there is such evidence. I am not.
Did she know what blood type was needed? Because the evidence shows as a fact that he made no, he didn't even take a sample for matching.
Until 6:40.
Until 6:40.
Yes.
So is there any evidence that she knew what blood type was needed at this stage?
No.
Well, that's why I wonder if it's more natural to read her inquiry as merely being a general inquiry, would blood be available? Because she wasn't in a position to say to the blood bank, I want blood of blood group X.
Well, except, my lord, that the problem with that interpretation is that it doesn't contend with the context. The context is, as has been put to me by various members of the board, that this was an urgent circumstance. And if a senior physician, albeit a pediatrician, is in the room with her, the woman who's on the table, to use my lady's phrase, is her personal friend. It's, with respect, inconceivable that she would not have asked the question that she gives evidence of having asked. And with respect, my Lord Hodge, my respectful submission, well, profoundly respectful submission, is that it is an untenable interpretation of this evidence to suggest that the physician friend of Mrs. Lezama was making a general inquiry as opposed to asking for blood.
But why?
Because, oh, sorry.
Blood matching later. I mean, she would have to know the blood type.
No, my lord, with respect, no. It is acceptable in medical circles that you can introduce a blood type that you either you've done the test and you're looking for matching, or you use the most common form of blood or the most common blood type, which I understand to be O negative. So, my lord, I want to be careful about, all that I'm doing is seeking to advance an interpretation of the evidence which I respectfully submit flows literally.
You say in the circumstances of a crisis, she must have been asking at least for a common form of blood.
I say in the circumstances of the crisis, she must not have been making a general inquiry saying that I'll come back later. I just want to know what's available. This is not a circumstance. In fact, it boggles the mind, with respect, to think that this could be a circumstance in respect of which an inquiry is made for with a later transaction in mind. That's how I'd like to put it.
Thank you very much.
Now, my lords, I have mentioned on more than one occasion the table of Dr. Bola Singh, and and I just thought it would be helpful at this stage to draw to your attention. It's to be found on page 917. And for those of you using the physical bundle, Mr. Brother tells me it's volume 3. Does my Lord have it? So, my Lord, what I propose to do is to make a few observations about this, and then I'm going to take you, if I may, to the cross-examination of Dr. Bola Singh. My Lords will remember that I was making submissions and trying to make submissions about expert evidence before I was grappling with my Lords and my Ladies' very helpful questions. So now that you've had a chance to look at the table, can I just make the following observation? That the blood volume loss estimated by the appellant, albeit there isn't a different amount, but there's a different a layperson's characterization of that blood loss by her husband. The blood volume loss 500 to 1,000 milliliters. Blood pressure is normal. These are the symptoms: palpitations, tachycardia, dizziness, and so on. And there is a degree of compensated shock. I want to contrast that to the blood pressure that we know was recorded at 5:15 in the agreed statement of facts and issues. And I think I shared that with you. It was very, very low. And there, it's a marked fall, 50 to 70. Well, that is at 5:15, her blood pressure was 46/25.
Well, the statement of facts and issues says 41/32, I think.
Sorry, I apologize. I'm looking at the chronology. Let me go to the statement of facts and issues then.
It's paragraph 15 on page 1153.
Well, it actually has two different, 17, it has a different figure.
Oh, yes, it does, yes.
Anyway, either way, it was very low.
Absolutely. And so 17 is 46/25, 15, it is 41/32. And so the point is that when you compare that to the table, and you bear in mind that this lady was also experiencing air hunger, collapse, and anuria, that the analysis that she merely suffered from post-partum hemorrhaging but having these symptoms is not consistent with the table and her evidence in chief. So what I would like to do is to take you to her cross-examination, and you will find that on pages 325, 326. To provide some context for the table that Dr. Singh Bola provided. And then I'll take you to the clinical assessment in relation to DIC and AFE. Page 325, if I may. Can I pick it up from line 15? Well, in fact, line 10. It is also not true that the average amount of blood that a person may lose before entering what is known as class 4 hemorrhage, and if you bear the table in mind, is about 40% of your circulating blood volume. And what this therefore translates into with the average human being is that you can lose approximately 2 liters of blood out of 5 liters before you enter the danger zone and becomes dangerous. And you can die from blood loss alone. Yes, but what I'd like to say is that it depends not only on the amount of blood loss, but on the patient's blood count at the start. So in other words, if your blood is normal, you could withstand far more blood loss than somebody else. And then down to the page, just to give context, line 43, but a pregnant woman actually has more blood than normal, and that's already been established earlier on.
And she also said it also depends on the rate of ongoing losses.
Absolutely, my lord.
Yes.
So while we're on her cross-examination, I'd like to take you to her responses in relation to whether or not AFE was a reasonable diagnosis. And that requires you to go from 325, 326 to 363, I believe.
I don't think there's any dispute that there is a general acceptance that AFE was a perfectly reasonable diagnosis, is there?
No, well, my lord, I hope not.
Yeah.
I look to my friend to see if that is right. So that on that basis, I can perhaps take this more shortly than I had intended. But to say the following things. First of all, my lord, the analysis and the questions and answers, what Justice of Appeal Barrow described as the concessions, to be found at pages 362 to 365, as to the reasonableness of AFE, did not form part of Dr. Bola's original report. So it's important to bear in mind that all the things that she said yes to and accepted as reasonable she did not identify them, knowing that the appellant's case was that this lady had a coagulation defect, DIC, and that he was attributing it to AFE. Now, the role of the expert is not simply to advance a thesis. It is, to borrow my Lord Hodges' phrase, it is also to deal with the counterfactual, or the counter-thesis, as it were. And so can I pick it up at page 362, just for a couple of points. Line 34. So having established at lines 27 to 30 that there are 2 phases. In the first phase, there's acute shortness of breath. My Lord Leggett, I think, asked me about respiratory distress.
I asked you, but
I do apologize, my Lord.
I accept that.
Yes, right. Lines 34 to 36, acute shortness of breath, hypertension, extreme high blood pressure. This rapidly progresses to cardiopulmonary arrest. And my Lord, so I ask you to bear in mind what I said earlier about Justice Rahim's findings at paragraphs 157 and 158. So these are the features, and they're there, and it's accepted. But on the issue of causation, over the page 363, line 11, and the question is asked, line 11, and the maternal mortality is high, with figures up to as high as 80%. Yes. It's also a condition that's considered to be unpredictable and unpreventable, correct? Yes. And what I understand this to mean is that you can't predict that a patient will suffer from AFE, amniotic fluid embolism, correct? That's correct. And there's nothing, if you can't predict it, there's nothing you can do to prevent it from coming on, correct? And so on. So just pausing there, so the evolution, as it were, of the condition is confirmed by the respondent's expert witness. So we've got three things. We've got, it has certain features, all of which the learned judge found. Secondly, there is a high level of mortality, or can be. And thirdly, the judgments of the courts below are conspicuous in their failure to come to grips with this evidence. They simply don't touch it. So, my lords, let me be open with you. Even assuming that you are dead against me on negligence, the case on causation, with respect, where you have evidence, and I want to be very clear about this, where there is evidence that you can analyze, you cannot, with the greatest respect, hide behind the coattails of the balance of probabilities. You can't. You've got to come to grips with the evidence, you've got to analyze it, you've got to make a decision. You can't say that you can't make a decision if you don't bother to analyze the evidence. There is not a scintilla of analysis, with the greatest of respect, in the Court of Appeals judgment. So having said at paragraph 14 that the material errors that they have identified entitle them to review all of the evidence, that is a task which, as on the issue of causation, they decline to enter upon.
I don't think you can say that. Because,
I'm sorry, my lord.
Because they accepted the evidence of Dr. Bowler, which they summarised at paragraphs 37 and 38, which gave several medical reasons why, in her opinion, AFE, although possible, was less likely than the alternative.
My lord, so can I permit me to just arm wrestle with you for a microsecond on that issue, my lord?
Yeah.
My lord, you are right. Paragraphs 37, 38, and 39, the Court of Appeal summarizes what's in her report. And so that my criticism of Dr. Singh Bhola was that in order to advance her thesis of PPH, she identified AFE as being questionable. And she said that in the report. My criticism of her is that which she goes on to concede, and I have only given you a flavor in the course of cross-examination, quite properly and quite commendably ought to have been in her report. That's point number one. Point number two, my criticism of the Court of Appeal, because I'm not on criticizing the witness, my criticism of the Court of Appeal is that there is no analysis of this material, analysis of the material, not recitation of it, my lord, so that's my respectful submission. My respectful submission is that its mere recitation at paragraphs 36, 37, 38, and 39 does not constitute analysis. And the Court of Appeal doesn't pretend that it is doing an analysis. It's not doing a summary or précis or of any sort. And so what we say is that had they conducted an analysis of the evidence, they would have had to grapple with the existence of the symptoms and of her condition, which that's uncontested. That's number one. They would have had to grapple with the fact that those symptoms were being explained by a condition that had poor prospects of survivability, and they would have had to have come to a conclusion on their own in respect of that. As far as causation is concerned,
what other than Dr. Singh Bhola's concession at 363
yes,
as to the mortality being high,
yes,
up to 80%.
yes.
What other evidence was led as to the poor prospects from AFE?
Dr. Jabode,
Yes.
at page, I think it's 973. Oh, sorry, 948.
948.
948. Gives, if I may say so, a very helpful summary in his written report. And
This is his written report.
that's his written report. And he is not challenged or contradicted in the course of his cross-examination on what he sets out in 948. And if you have 948, then you will see that what he does, he supports what he has to say there by reference to the literature. Williams on Obstetrics is a North American textbook. I believe it's published in Texas. Maybe that doesn't matter. He describes the disorder. It classically is... Does my lord have it?
Yes.
I apologize. Yes. My lady? Yes. It's a complex disorder classically characterized by the patient by the abrupt onset of hypotension. My lord's 515, whether it's 41 or 42 or 47 of the blood pressure, that's there. Hypoxia, consumptive coagulopathy. I said I wouldn't say it, but I did again. There is a great individual variation in its clinical manifestations, and women are encountered in whom one of these three clinical hallmarks dominates or is entirely absent. The syndrome is uncommon in an absolute sense. However, to answer my lord's question, it's a common cause of maternal death. So this is not Dr. Jabode expressing his opinion. This is the literature in the leading textbook, as I understand it, on obstetrics in the North American context. That's gone to its 22nd, at that stage, 22nd edition. It might be 24, 25 by now. Classically, a woman in the late stages of labor or immediately postpartum begins gasping for air and then rapidly suffers seizure or cardiorespiratory arrest, complicated by consumption coagulopathy, massive hemorrhage, and death. She experienced consumption coagulopathy, hemorrhage, and a drastic fall in BP and cardiac arrest, which led to her demise. And this is consistent with the diagnosis of amniotic fluid embolism. Dr. Achong asked the patient's husband to consent to an autopsy. Well, that's... Yeah.
It would help me, if at some stage, maybe after lunch, you could give the references to where you say there was evidence of respiratory problems or gasping for air or anything of that sort.
Yes.
Lack of oxygen.
Yes.
Because you said in answer to my Lord Hodge that there is such evidence. It would help if you could
I'm obliged,
give us the references.
Yes.
It goes on in the next paragraph
Yes.
to say that the AFE diagnosis was reasonable.
Yes.
And the mortality rate is said to be between 20 and 90%.
Yes.
Yes. So it's a huge range.
It's a huge range. This is, well, we all know about science.
Now,
does that mean that there are different studies that have different figures, or I mean,
well, my lord,
90% is
I would be guessing by
meaningless, really.
But I would the honest answer that I would give is that the literature, and only some of it is obviously was only appropriate to produce to adduce some of it in this record. Sure. The literature is consistent with saying that there is a range. Yeah. My short answer to that, to the underlying question, which is that on the facts of this case, subject to, of course, me satisfying my Lord Legate about the evidence, that these features were present in this lady, and that each of these obstetric experts ended up saying that given the presence of these features, and these are just the summarized ones, that the diagnosis was a reasonable one.
Well, that's to say it's a reasonable possibility, but on the question of causation, it's the question: is it
Yes.
more likely or less likely than not?
Absolutely, my lord. Which is where I was trying to say that where the courts below fell down, as it were, is not engaging in the arm wrestling that I think is necessary for any party to say, well, listen, I've had a fair crack at the wicket, I've had my chance, my case was adjudicated upon, I won, I lost. That's not the complaint. The complaint is that someone took away the ball and the bat in the wicket. Perhaps I shouldn't make them. So, my lords, over the pages of 365 onwards, counsel identifies 14 signs. If you see that at the top of page 365, 14 signs or symptoms that present with various frequencies. And he takes this witness through them. He does the very same with Professor Daisley. So it's helpful in order to answer my Lord's question, in part, before lunch, to try to find the one with respiratory. But can I just pick it up? I'll ask my junior to help me tell me where that is. But we've got hypotension, line 11 and 12.
Yes.
You've got pulmonary edema, lines 27 to 28. You have cardiopulmonary arrest, lines 32 to 34. You have cyanosis, but that did not present. You have over the page in 366, coagulopathy, that's line 17 to 19. And my Lord, to answer my Lord's question, Lord Legard, this is the first of the instances I'll give you. It is lines 28 to 32. Dyspnea, which is defined as shortness of breath, or according to Google and Wikipedia this morning, it means gasping for air. And to the answer to the question as to whether it existed in this case, lines 35 to 37. Does my Lord see that?
Yes, thank you.
Yeah, it presented itself in our instance, didn't it? According to the notes, yes. And then we have, again, for the purpose of analysis in relation to causation and these alternative theses, uterine atony played a part in AFE, correct? It's another sign or symptom of it. And I say this all to make the point, or to underscore the point, that what was required from the court was grappling with this, not, I mean, I've said this already, not as recitation, but an analysis, applying it to the facts of the case in order to determine, right, one way or the other, whether the appellant's case as to causation, because the way that things transpired, it was almost as though the appellant bore the burden of establishing that amniotic fluid embolism led to DIC and led to these conditions, which led to her death. And if that's the right way of looking at it, that is to say, if it's the right to analyze the appellant of having such a burden, and I don't concede that, but if that is right as a matter of law, then we say that the Court of Appeal, A, ought to have said so, and B, ought to have said that he had discharged that burden.
Well, this is on causation rather than merely on
absolutely, my Lord.
AFE. But the evidence on the mortality caused by AFE is simply, so far, all we've seen is a concession that it can be up to 80%, and a reference to a textbook where the range is put between 20 and 90%.
Yes.
Was there not also evidence from the appellant himself that he had encountered this on a number of occasions, I think on 5 occasions,
yes,
and that he had succeeded in saving the patient on 4?
Yes. Yeah.
Yeah.
My Lord, yes. My Lord's recollection of the evidence is absolutely correct.
Yes. So I mean, it may be one thing to say that the courts should have grappled with this, but if that is all the evidence that was before the court, why do you say that they should have said that there was, on balance of probability, no causal link?
My Lord, I didn't get the last 6 words of what my Lord just said. Why do I say...
Why would you say that on the balance of probability there was no causal link?
Well, my Lord, I hope I'm not misinterpreting my Lord's question. My submission a moment ago was that the court below had an overwhelming body of evidence, and that's why I've taken you to the respondent's expert, to show that the causal link between the condition that Mrs. Lezama suffered from and AFE had been established.
Well, all that evidence shows that you've taken us to is that it was a reasonable possibility and that it was consistent. But all those symptoms were also consistent with the alternative explanation.
Well, my Lord, with respect, no. That's not the evidence. That's not the evidence. The evidence and the purpose of the cross-examination was to demonstrate the exact opposite of that proposition. The purpose of this cross-examination was to demonstrate that what Dr. Singh Bola had not taken into account, even when she was, as she was entitled to, castigating the AFE diagnosis as being questionable, was that she had not taken on board all of the features with which she was familiar. So she says at the beginning of this cross-examination, I am familiar with that literature, because counsel introduces it by identifying the journal. And he says, well, I've got this from the journal of whatever it is, anesthesia and analgesics or whatever it is. Yes, I'm familiar with it. Tell me what it says, is what she says to him. And he goes through them one by one. And it's not simply, it is, the evidence goes on 2 tracks. The first track is the establishment of the reasonableness of the condition. The second is directed to establishing that this was the cause of her demise.
Well, where is it put to her that this symptom or that symptom is not consistent with the alternative diagnosis? That isn't suggested.
No, my Lord, no. But my Lord has quite properly flipped the question. Where is it put to her that it was not?
Exactly.
So my Lord...
All that this is showing is that it is a possible explanation, because it is one way of explaining most of the, or many...
of the symptoms.
Of the symptoms that presented.
Yes. But in answer to my Lord's question, there was no evidence adduced by this witness, who was a respondent witness, to suggest that these symptoms, these features were consistent with a diagnosis of postpartum hemorrhaging. That's how I wish to put my proposition. So I say it has 2 parts. The first is no such evidence was adduced by her, and no such evidence was adduced by any other witness called by the respondent. And then, as it were, positively, to the extent that there's a positive case upon the shoulders of the appellant, the positive case was, this is what he sought to establish.
I can see where you take it, in the sense that you say, by reference to this cross-examination, that the DIC, which was identified as the principal cause of death, may well have been caused by AFE. But how does that lead to the conclusion that there was nothing that the appellant did which gave rise to, which could have prevented the patient's death?
Well, the first answer to my Lord is, first of all, there is no positive evidence adduced by the respondent to that effect.
No.
That's the first answer. The second answer is that to the extent that the thesis as to the condition under which Mrs. Lezama was suffering was PPH and nothing else, that is destroyed by her cross-examination. And the third answer is that the alternative explanation as to her condition turns out not to be a partisan position adopted by the appellant, but now, as a result of the cross-examination, has the benefit of the support of experts on both sides of the adversarial aisle. And then fourthly, when it comes to pulling these threads together for the purpose of determining whether or not any of the breaches of his professional negligence standards caused or contributed to the demise of Mrs. Lezama, the first answer is, well, that's the job of the respondent. It was for the respondent to adduce evidence that, notwithstanding, because this is an instance, and I'm sorry for interrupting myself.
Well, I mean,
this is an instance.
With respect, you're moving your ground.
I'm sorry, I apologize.
What you said earlier, as I understand it, was you didn't accept that the appellant had the burden, and that's what you're saying now. But you said, but if he did, it should have been, the Court of Appeal should have said he discharged it.
Yes, yes.
And so, again, I get back to the question and ask you, let us assume that it were established that the cause of the DIC was AFE. Why do you say, on the very limited evidence that was led about mortality, including the appellant's own evidence that he had saved 4 out of 5 women that he'd encountered with this condition, why do you say that he has discharged that burden, if indeed there is a burden on him at all?
Okay, my lord. So I apologize because I was getting a little bit carried away. I had gone beyond that line of thought.
No,
I had gone back.
The point I'm wanting to ascertain.
Lord,
let us assume,
and I'm very grateful.
Your benefit that
yes,
that on balance of probability we have AFE as the cause of the DIC.
Yes.
How did, in your words, how do you say that the Court of Appeal should have said the appellant had discharged that burden?
So, the appellant's defense and witness statement were at item in saying that AFE-induced DIC led to Mrs. Lezama's demise.
Yes.
The defendant, when challenged, as it were, as to his degree of confidence about the diagnosis of AFE, simply explained that over the course of his 30-plus career, 30-year-plus career, I apologize, they all began to practice in the early 80s or late 70s, that he had seen 5 such cases.
Yes.
It was open to counsel for the respondent to explore any one of those other cases, their circumstances, their conditions, and so on. All that the appellant was saying was that, as physicians often do, I have seen this before. By contrast, I'm sorry, my lord. No.
Please continue, please.
By contrast, Dr. Singh Bola said, I've never seen it. That's not a criticism as such. After all, she was 4 years post consultancy. She had reached a level of consultant, and she'd been practicing as a consultant for 4 years. So it is not surprising that she hadn't seen it. Dr. Jabod, who had a comparable degree of experience to that of the appellant, said that he had seen one case before.
Yeah.
So that, and I'm hoping I'm trying to get come to grips with my Lord's question. To the extent that the appellant had any burden at all, we say both his evidence and that of Dr. Gibaud as to the nature of the condition and its manifestation in Mrs. Lezama identified those features as a cause of her demise. So, my Lord, this is not a question of numbers. I'm not relying on numbers as such in an absolute sense. It is part of the context, obviously, but that's not, if I might put it this way, it's not where the burden of the evidence, the core burden of the evidence upon which I rely goes. And so that my, this is where I had kind of, before my Lord's question, I was simply swinging everything back to an analysis of the judgments down below and simply pointing out that the conversation that we are having is not there. The probing that you are quite properly subjecting me to is not there. They had the advantage, they had the benefit of all of the evidence, and so that what happens in the judgments is, and I mean no disrespect by saying this about the judges before whom I appear on a regular basis, recitation is not analysis. So that when one advances with diffidence and respect the criticism, as I did throughout my case, of fail to have regard to, it's not a simple didn't have any notice of it at all, although that happens too. Fail to have regard to, for the purpose of this conversation, means grappling with. Fail to have regard to means engaging with the reasoning. So that, just by way of an illustration, on each and every instance in which this board and its predecessor members have said, we will, by way of an exception, depart from our well-established, self-imposed reticence from disturbing concurrent findings, it has always been able to identify a series of flaws or a flaw in the reasoning. So that's the same standard.
Well, as Lord Leggett has pointed out, in this case, you don't have to overcome the concurrent finding rule in relation to causation.
My Lord, I'm not rejecting the gift, if I can put it like that. What I was on by way of analogy was really, and I hesitate to say anything about reasoning and logic before a panelist distinguishes this, but it just strikes one as a matter of legal logic and reasoning that you can't legitimately avoid scrutiny by either having reasoning that's so compressed it's impossible to tell what your reasons were, or, as I say in this case, disregarding the evidence in the sense that I have used that term, disregarding the evidence, meaning not grappling with it, or put it another way, not doing what the House of Lords in Bolitho said must be done in causation cases,
Well, we understand that point. Can I bring you back to one aspect of the evidence that you've been focusing on, which is the 14 signs of AFE?
Yes.
And I'd like to ask you the equivalent to what Lord Hodge asked you. Just supposing for a moment, I know I understand all your point about the burden of proof, but supposing that you are seeking to argue that on the balance of probabilities, AFE was the underlying cause, was there any evidence that any of the 14 signs or symptoms would not be explicable by way of a DIC with a different cause? I mean, for example, we know that hypotension, low blood pressure, can be simply a cause of blood loss. Cardiac arrest, if you lose enough blood, you don't have enough oxygen, your heart stops beating. DIC, as I understand it, can cause problems with organ failure because you get clotting internally.
Yes.
So was there any evidence that any of those 14 symptoms was, as it were, unique or particular to AFE, as opposed to simply being symptoms that would or might well have been present as a result of hemorrhaging accompanied by a coagulation problem, which was not caused by AFE?
Well, my lord, can I take the second half of it first? My lord, doing the best I can, there was no, how do I put this? There was no alternative thesis that sought to account for the overriding number of symptoms. I don't know if that's helpful or response to the question. But to answer the first part of my lord's question, which is whether or not were any one of these 14 features, and let me see if I understand this correctly, were unique to AFE? Would that be an accurate way of putting it? Yes.
Or not also explicable or consistent with DIC with some other cause. We know that DIC is a number of causes.
That's absolutely right. So I think that the objective answer is that there was no evidence that sought to explain the overwhelming majority of symptoms that were identified by reference to another cause. So, my lord, I appreciate that's not a complete answer to my lord's question, because you ask hard questions. So, but
was there any? But put it another way, was there any of the symptoms that was not explained by DIC and together with a very large loss of blood?
Any other symptom?
Any of the symptoms here? Is there any of the symptoms here that would not be explained just by DIC? What was on the death certificate, in other words? Was there any of these symptoms that was inconsistent with the cause of death as stated on the death certificate?
Well, Lord, I'm going to give an answer, but I'm going to ask you to let me have a second crack at the wicket after lunch. I think the answer that I'm going to give you now is no, but I'm searching my memory. But, my lord, if over the lunch break I have to revise or concede, then that is exactly what I will do.
Thank you.
May I just take up that last point raised by Lord Leggett? And it is this issue of the death certificate.
Yes.
And the diagnoses made on that, the first, primary and secondary cause of death.
Yes.
Let me take your case. It was a possible diagnosis or a putative diagnosis on the part of the clinician, and that is why it wasn't entered on the death certificate.
Yes.
Isn't a reasonable inference to be drawn that if he did put that on the death certificate, he was satisfied that the symptoms as they presented to him were consistent with the diagnosis he put on that certificate? All the symptoms that have been identified, he was satisfied they were consistent with DIC which was the result of PPH?
It's the last part that I take issue with. So,
he's the one that put it there on
Yes.
the certificate, and he couldn't have put it there if he didn't think the symptoms were not consistent with it.
So he put DIC and PPH on the death certificate. And so, Milady, we're back to how we began our conversation this morning.
Yep.
DIC can lead to PPH. AFE can lead to PPH. The contemporaneous entry on the medical certificate is consistent with that which he observed. His explanation for not putting AFE was that it was a presumptive diagnosis. Those are the words that he used. He even makes a joke. He says he's not a presumptuous person. Doesn't quite mean the same thing. None of those facts or factors are inconsistent with the contemporaneous facts on the ground, as it were. In other words, all of the features that we've spent the last sort of 15 or 20 minutes discussing were actually observed, were recorded, were referred to in the notes, and that's why each of the experts were prepared to. I'm sorry, my lady.
No, listening.
I don't mind. Forgive me, my lady. When we wear masks, we tend to read people's eyes now. That's all that happened. I apologize.
What I can do about this.
so I didn't mean to be inappropriate or impolite. Sometimes you think an eye is asking a question. So those features are themselves contemporaneous. So my lady, my real answer to you is this: is that the range of symptoms, the range of conditions, were all recorded on the afternoon and the evening of April the 6th, 2003. The appellant records, he's asked to record, he's obliged to record primary and secondary cause of death. And that's what he does. His failure to record AFE does not undermine or contradict the existence of the symptoms as they appear at the time, and as analyzed slightly more leisurely, we have to accept, with the benefit of learning from books on obstetrics, from articles and so on.
No, I accept all of that.
Yes.
Mine is at just a much shorter and simpler point.
Yes.
And it goes to the matter raised by my Lord Legate, which is that the symptoms that have been identified
Yes.
are also consistent with the diagnosis that he put on the death certificate.
But, my lady, I'm waiting for you to go a little bit further. In other words, if my lady is simply putting to me that it is consistent with DIC and PPH, then I'm not resisting that suggestion. All I am seeking to do is to give if I might put it like that, an explanation within a context.
Thank you very much.
I apologize for not getting there, as
not at
you
all.
asked a perfectly fair question, and again. Now, my lords and lady, I've spent a lot of time, I think, on the evidence, but I think it's helpful or fair to try to draw the threads together as to how we say the expert evidence ought to have been approached by the courts below in more generic terms, but of course applying it to the facts of this case. And you have in our written case the way that we approach it. But I thought it would be helpful to connect what we said there to what I've already So if I can ask my lady and my lords to bear with me. I'm merely making all the submissions by way of elaboration on paragraph 65 and 66 of my written case. In an attempt to tie the threads together of what it is we've discussed so far. So what you see there, if I can, I hope not impolitely, is a series of further and better particular propositions about the reasoning or lack thereof as to when one comes to analyze or consider expert evidence. So we start off at 66 by simply consistent of, because what I think is Miss Justice Green in the North Cumbria case followed Bolitho and identified the requirement that expert evidence has to have the following features. It has to have logic, it has to have reasonableness, and it has to have competence. And I've hinted, and I've made submissions already, that our Part 33 and your Part 35 of the CPR, in a sense, sets out how those requirements are met in this sense, in the sense of you are required to consider, as it were, the other side. That's why experts are experts of the court. They are not witnesses or guns for hire for partisans. They are there to act as officers of the court, and of course all of this, my lords and my lady, is well known. What that means is that it's necessary for the court to test, this is 67.1, to test any expert evidence against other evidence, and of course test it on its own for internal consistencies. Secondly, to consider very carefully whether the expert has addressed all the relevant considerations applicable at the time. Thirdly, whether the expert is alive to a tendency to hold on to a thesis or a particular perspective, and also competence. And competence, of course, here means qualifications and experience. And so what we say in general terms, having regard to the conversation that we've had so far, is that the experts who gave assistance to the court, Dr. Jibod and Dr. Prasad, had 6 or 7 times more experience than Dr. Singh-Bola. Secondly, they discharge with conspicuous fairness their obligation to the court, which, put bluntly, means that if your expert and objective opinion requires you to say something adverse to the party who was calling you, then that's what they did. Thirdly, we say that when one comes to consider their cross-examination, my lords and my lady will see that very limited qualifications or concessions were necessary to be extracted from them. Further, that was not the case as far as Dr. Singbola's evidence was concerned. And that was because they had, in their reports, addressed all of the relevant considerations, whereas Dr. Singbola did not do quite as well in that respect. Having said that, I want to repeat that her concessions in cross-examination were commendable, responsible, and correct. So that when we say at paragraphs 68 to 76, we identify a series of tests which the court did not subject the evidence to. And if I can just use 68 and 69 as a template for my submission. So this is a template as to testing, it's a template for determining the rationality, coherence, reasonableness of the expert evidence. So in paragraph 68, we point out that Justice Rahim was required to test Dr. Singbola's evidence against the signs and so on, which is what we took you through. And that at paragraph 69, we point out that Dr. Singbola's evidence, which was accepted or relied upon and referred to, was to be tested against the testimony of Dr. Daisley, Dr. Jabod, and Dr. Prasad. And then all of that evidence, when taken together at paragraphs 70, is to be tested by the underlying factual material that is common ground among the parties. In order for the question that Lord Leggett has asked, and joined in that question by my lady, as to whether or not, if I could use general language, there was an alternative explanation that was credible. And so respectfully, our submission is it wasn't, and it's not to be found in the reasoning of the courts. In other words, if we just choosing Roman numerals 1, 2, 3, 4, 5, 6, and 7 of paragraph 70, none of these are features that appear in the analyses to the extent that they existed at all of the courts below. So we say, with Justice of Appeal Barrow, who wrote the leading judgment for the Court of Appeal, correctly that the case turned upon, as it were, to use a euphemism, a battle of the experts. But really the battle was issued by the courts below in the way that I've already set out. Finally, we say with the greatest of respect that the reliance upon the notion of balance of probabilities is acceptable in two circumstances that come to mind. The first is if it's properly understood and deployed. So what do I mean by that? A recitation of the notion of balance of probabilities does not reflect complexity. So to use the obvious example, completely disconnected to this case, where one has to grapple with, let's say by way of example, an allegation that someone is lacking in probity, one looks for a certain degree of coherence on the evidential plane that is not answered by a simple application of the burden of proof notion. What we say occurred in this case is that there was, before the courts below, helpful evidence on a complex issue involving medical condition and causation that the courts did not regrettably take advantage of. Had this been a circumstance where there had been such analyses in the way that I've set out at paragraph 17, just by way of an illustration, that's all it is. In other words, a testing of the evidence to see what it is established, and the scales were evenly poised, then in those circumstances resort to the notion of the balance of probabilities would have been acceptable and conventional, respectfully. But the absence of analysis is sufficient here to trigger appellate review, appellate reconsideration, and setting aside.
I wonder, I mean, we'll soon be coming up to the lunch break, and I want to put to you something that is still concerning me, so you've got a chance to think about it and perhaps...
My Lord, I fear you're about to ask me a question probably more difficult than Lord Leggett's.
Give me a... it's a question I've asked before, but
oh dear.
I will return to it. I'm again puzzled by the idea that on the thesis, or the hypothesis, that DIC was caused by AFE, that there was therefore no causal link between anything that, that the appellant failed to do and the patient's unfortunate death. And can I refer you, you speak about a battle of the experts, but can I refer you to Dr. Gibaud's his report at 948.
948, yes.
Yes, at the bottom of page 4 of his report, he records the range of mortality rate, and he says that it's a rare event, and he says this rare event could not have been anticipated in such a rare, unpredictable event. One would not be expected to have blood available in the nursing home prior to delivery. Now, the inference of that is that if it had been anticipated, the correct thing to do when faced with AFE was to have blood. That's my first point from his report. And then in the penultimate paragraph of his report on the next page, he says, in view of the emergency that arose at the delivery and the resources available at the time, it is my opinion that Dr. Lowe acted in the best interests, and the patient unfortunately died despite his best efforts. Now, there doesn't seem to be an assertion by the doctor, by the expert here, that if blood had been available, it would have made no difference, or it was unlikely to make any difference. And so I'm still struggling to be clear in my mind as to why you say the fact that the court, on your submission, did not consider in any detail the diagnosis of AFE means that in some way the causation case of the respondent must fail. But this is a question for after the short adjournment, I fully accept. I mean, would that be a convenient place at which to
my Lord, yes.
interrupt proceedings?
Yes, sir. I'm very grateful, my Lord.